Good morning. Welcome to Sterne Kessler. It's a pleasure to host this briefing together with Public Citizen, Inc. and American University Law School. I'm Jorge Goldstein from Sterne Kessler, and I wanted to just share with you one or two logistical issues. First of all, the password to get into the local internet, which is SKGF guest, I guess, is Operation Army. Don't ask me why. It's Operation Army, one word. Bathrooms are over there, past the reception area. When you speak, you need to pick up the mics that are in front of you. So if you raise your hand and say something, from over there, the folks over there are not going to be able to hear you very well. We're still trying to work out the acoustics in this room. So please pick up the mic, and the mic is now flashing red. Press the button just once, and it'll turn green, like this one. And then when you're done, turn it off, so the next person. The speakers are all over the place, but the mics are local. We are hosting this together with AU Law School and Public Citizen because Sterne Kessler has been an IP high-tech patent law firm and IP firm in Washington for close to 35 years or plus, and we've had a pharmaceutical and biotech practice for about the same amount of time, and pharmaceutical patent law is critical to the work that we do. And we try to follow cases and bring people together who are interested in this. We have represented innovators, we've represented generic pharmaceutical companies, and we have an active pro bono practice which deals with access to medicines in the developing world. So we are very much involved in the legal aspects, in the intellectual property aspects of pharmaceutical patent law. I had never heard of the so-called promise of the invention doctrine until somebody said to me, there is this thing called promise of the invention doctrine in Canada, and Eli Lilly is suing the government of Canada for violation of NAFTA rules. And I said, well, how bizarre is that? And then I got a call from Public Citizen saying, could we have a briefing on it? And I thought, sure. I learned something because I'm not an expert on it yet. And the reason we are not quite in there yet is because the United States Supreme Court hasn't gotten its hands on it yet. I'm pretty convinced that the moment somebody from the Supreme Court hears what's going on in Canada, our esteemed Supremes will decide the time has come to mess with a utility requirement in the United States too. They have left almost untouched in the last few decades, 20 years or so, especially in the last 5-6 years. Just this week, we had a decision on the indefiniteness requirement from the Supreme Court called Nautilus. We had another decision on inducement to infringe called Limelight. And it comes in the wake of the Myriad decision where they touched the eligibility requirement, 101. So I think it's just a matter of time before they start messing with the utility requirement, and the sooner we hear what's going on around the world, especially our neighbors in Canada, the better. So, without further ado, Peter, you want to introduce the conference? Here. That on you? All right.
There we go. Great. Thank you, Jorge. Good morning, everyone. It's very good to be here. My name is Peter Maybarduk. I'm the Global Access to Medicines Program Director at Public Citizen. Public Citizen is a consumer advocacy organization based here in Washington, D.C. We have 300,000 members and supporters and a 40-year history representing consumer interests before Congress, the executive agencies, and the courts. And among our other programs is a program called Global Trade Watch and another, the Global Access to Medicines Program, both of which are quite concerned with this case. I believe we'll have Ben Beachy in the audience as the day proceeds, who is an investor state systems expert from our Global Trade Watch division and can supplement our conversation in that regard. Thanks very much to American University and to Sterne Kessler for organizing and hosting this event. So we're here to discuss a case, as Jorge has alluded to, that could have significant ramifications for our medical innovation system, as well as for patent litigation and essentially domestic court sovereignty. Over the past several years, generics firms challenged patents held by Eli Lilly successfully in Canadian courts. Canadian courts invalidated 2 Lilly patents related not to active ingredients, but rather secondary use patents, one on olanzapine, an antipsychotic marketed as Zyprexa, and the other atomoxetine or Strattera for ADHD. Unhappy with these decisions, in November of 2012, Eli Lilly filed a notice of intent under NAFTA's investor arbitration system, a notice of intent to sue Canada for $100 million for the denial of this patent protection. And that was updated in September of 2013 with a notice of arbitration augmenting the amount at stake to $500 million. So I think at stake for all of us in the room are a couple of very key issues. One is this is the first intellectual property-based investor state challenge that we've seen, and there's a significant question for all of us in the room whether more cases will be removed from courts, will be removed from the traditional domestic national systems of examination and national rules, and treated under the investor state system with a different set of procedural rules and some different interests at stake. And secondly, how this will affect the standards which govern medical innovation, and the question of which rules support true innovation, what should be the scope of secondary use patents with the sort of incentives that can drive medical innovation that we need on the one hand, and the balance with access to medicine's interests and healthcare costs, and excluding competition unfairly on the other. And we have 2 panels of distinguished speakers to address these issues for us today. The first will deal specifically with the details of the case, the drugs and the rules at issue, and the second will consider in a broader light the legal and policy questions surrounding secondary use patents. And with that, I believe I can turn it over to Professor Alai from American University to introduce our first panel.
Thank you very much. I'm Patty Dalai. I actually